because I just want to make sure it's clear. What counsel produced to you is actually lifted from the complaint, not what we intend to present as we present it. So there's actually components of the complaint on what's been provided. I can provide to you the actual boards that we're hoping and anticipating to put in the opening. So in the form that they'd be shown, if that helps the court, because it does not have.
Because I just see some exchanges of names and information that, in addition to the images, make me somewhat concerned. And by the way, I will also say too that I say this for the benefit of CBN that's streaming, which is I believe there's been clear communications from the branch about not broadcasting or photographing these sensitive images and exhibits. So the courtroom is as open as we can make it, but it's not open without sensitivity to some of these issues we'll be discussing throughout the trial.
Okay, thank you. And just for the record, Your Honor, I understand that Mr. Migliore is telling us now that these images will not be presented in the form that is in the slides, but what I've handed the court is exactly what the state shared with us when it made its disclosures.
Your Honor, and if I may on that point, first of all, may I approach?
Yes, you may. Thank you.
Aaron, I apologize. I can see the podium for you.
Your Honor, this is the first disclosure of the case, and just to show sort of the mechanics of the trial, we disclosed based on the exhibit numbers and how things were produced. The court's ruling was that we didn't have to produce the slide itself the way it was going to be used in opening. So the disconnect is an unintended one. We actually disclosed the exhibit number, but for purposes of the opening, we took out what I believe were the court's concerns about words around the photographs and the like. So they are the same images, just removed from the way that the exhibit shows, and we can substitute, if the court wants, the actual exhibit to the way we've brought it here. But we've taken out any of that extraneous information the way it's been disclosed. And obviously, Your Honor, going forward, we'd be sensitive to and make sure that there wouldn't be a disconnect like that in the future.
Okay.
But the state, just one more point, Your Honor, if I may, the state has no interest in re-victimizing anybody. Our goal here in producing these the way they are is to protect and to, by all measures, protect these folks, but also present very difficult issues.
All right. With respect to one of these exhibits, it's DX3188, for instance. Is that a fake account for the investigation, or is that a real person's?
That is one of the undercover accounts.
Okay. Just trying to make sure there's one thing in terms of the concerns we're discussing for undercover accounts, another if we're pulling real.
Correct. No, in fact.
Images. And is that the same with respect to the ISAB?
Correct. The two that have the plaintiff exhibit 4117, those are all from the ISAB account. Okay. And then this defense exhibit is from another account by the same investigator called Daisy.
All right. And with respect to the exhibit, it's numbered them here, but it's page 42, I think, is what it shows up on the slides.
Correct.
There's a slide with, in the reference picture of a young girl in a swim attire, and above her image, there is an exchange that would appear to show potentially identifying information. Where is that information from?
So that is from the actual post. We could redact that very quickly, Your Honor, if that's what the court's ruling would be. That is another image that was posted to this ISAB account. So it's from the same investigation, from the same undercover account, just a different post. To the extent there are names there, we could absolutely redact that in an instant.
All right. All right. I think with that, the risk of revealing sort of like non-party, non-investigative information would be addressed.
Okay.
Please make those redactions. And then consistent with the court's earlier rulings and comments, let me just say with these, with that redaction, objections overruled, including on the 403 front, I think, as I understand it, a necessary aspect of this case with respect to misrepresentations is going to be, I assume, over a number of weeks to show misrepresentation or representations, I should say, and then sort of the reality of what people were experiencing on the platform so that the jury can gauge whether or not their misrepresentations violative of the UPA or not. And so on that basis, I do find that while these images are disturbing, that they are part of what needs to be, at least in terms of topic, what needs to be shown to the jury. One other comment, though, just to make clear, which is, and this is Mr. Migliore while you're standing up, and Ms. Stambaugh, I know that you stepped down, but you're still going, and that is, I think the comment has been raised that really there's a risk of the plaintiffs in showing this, whether or not this evidence gets in and the like. And I just want to make it clear to everyone so that the full scope of that risk is understood. I am sensitive to the fact that in allowing these to be shown, if these exhibits are not admitted, there may, I would expect, very well be an instruction from the court pointing out these were shown to you, but you have not seen any evidence in this trial that makes them admissible for you to consider and the like. So just in case the idea from the plaintiffs is show them and then we'll see 7 weeks later if there's anything other than a bad impression left with the jurors, I think the court can and would address that at that time. So just so everyone is clear going into openings that it's not just, well, we didn't get it in, but we got to show them. There may very well be an instruction from the court, if appropriate at that time, related to the fact that they didn't get it.
Clearly understood. Thank you.
Great.
With that, the objections thus far overruled. And I think Ms. Stambaugh still has the floor, but you were very helpful. What's that?
If I may, I'm just going to introduce you to Gina Veldman, our technician. I'm going to have her do this while we start the next one.
All right. And thanks to everyone that is making the technology work smoothly, as has been evidenced in the pretrial hearings. I am certainly unable to do that sometimes, so I appreciate that very much. Ms. Stambaugh?
You and me both, Your Honor. One point of clarification on this ruling, just because, and I'm not trying to be difficult, but just because the court didn't say, because the image of the little girl in the bathing suit had only been disclosed in this case in a black and white version, and we were seeing the color version for the first time, is the court willing to hold the state to showing the version that was part of Ricky Kitch's report, as opposed to the color version, which we had not seen until about 48 hours ago?
All right. I do not find that the difference between black and white and color is substantial enough to warrant upholding that objection. So with that, as long as the image has been shown and the like, that objection is overruled.
Thank you, Your Honor. just as a point of sort of more logistics, we would respectfully ask for a standing objection to the state's introduction of third-party posts based both on Section 230 and because we still contend that these risk re-victimizing the children shown in these images. Is Your Honor willing to grant us a standing objection so that Mr. Huff does not have to stand up and interrupt Mr. Migliori's opening?
Certainly. Anyone from the plaintiffs want to respond to that?
Your Honor, we don't have a problem with a standing objection. We'd prefer not to be interrupted.
All right. And I will say as well that throughout pretrial motions and the like, I think you all have been very consistent. I will strive to be as consistent throughout trial in my ruling with your objections on the Section 230 basis and the like. So that is granted.
Great, thank you. This is
I
another.
guess I should say it's a standing objection that's granted, not a sustaining of each of those. So just to be clear.
Understood, Your Honor. Thank you. Similar to our request for a standing objection on this issue, in our meet and confer with the state yesterday, the state did not commit whether it would be referring in its opening to lay opinion testimony that we contend is hearsay, violates Rule 11701 under motions in limine 23, 35, and 36, or reports for which the data was not enclosed under motion in limine 41. So in order to avoid wasting the jury's time and needlessly introducing white noise, we would just also ask for a standing objection under Rule 11701 for those reports.
All right. And counsel for the plaintiffs.
Your Honor, on this, it's a little finer of a point, if I may approach.
Yes.
We had a motion and a hearing last week about what we had to disclose and what we didn't. Creatively, counsel came to the meet and confer with questions about everything that we had in the rest of our presentation by wording it to say, well, we want to make sure that you haven't, to quote them, end-rounded any of the rulings of the court. Without having taken offense to the suggestion, I said that the state has governed itself by the rulings of the court, and we've disclosed the issues that required leave of court in order for us to proceed, as well as the images and the statements of congressional testimony that were in question. So the long and short of this, Your Honor, is there isn't and shouldn't be a standing objection to whether or not the state complied with the court's orders to date. It was another way of trying to find out more about whether or not or how we were going to talk about, for example, Mr. Behar or Mr. Kitch or some other folks. And so I just have a little more problem saying there's a standing objection to whether we've conducted ourselves appropriately.
All right. And just so that I'm clued in, with respect to openings, what is it more specifically that we're focused on from the rulings last week?
So there are a number of lay witness reports that are at issue in this case. Some of them, I'll deal with one specific report and some testimony associated with the report next. But the reports come from witnesses that are fact witnesses. They're not experts. A number of these studies and reports, the underlying data for the reports was not disclosed. That was a requirement under one of the court's motion and limine rulings. We have, as much as we can, taken the state at its word that it is not intending to introduce improper evidence, but it did evidence on our meet and confer an intent to introduce some of the information from these reports without us knowing what that specific information is and not wanting to waste the jury's time or interrupt the state's opening. Our proposed remedy is simply to seek a standing objection to the extent the state does present that information.
All right. And Mr. Migliori, you perhaps can shed some more specific light on the concerns zone.
I wish I could, Your Honor. This idea that I expressed an intent to show something that they didn't want me to is beyond me, Your Honor. What I indicated was we'll be talking about the testimony of the various witnesses. I'm not going to be publishing any reports or findings that the court has not allowed us to publish or that are subject to leave of court. So I have no idea what the reference is to. I can tell you that to the extent that there's any lay witness that has an intent to testify in this case, I have every intention of representing that this is the person who's going to testify, this is this person's personal experience, and this is the types of things this person did. But to go into details of reports that are subject to rulings, there was never an intent expressed that I would be doing that.
All right. What I take from this is that plaintiff's counsel is indicating that there will not be evidence disclosed, or argument based on evidence, I should say, in openings that runs afoul of the court's rulings. If that happens, I guess rather than a standing objection, object, and we'll deal with it. On the other